Been joined by the Honorable Councilman Paul Krikorian. We're anticipating, I believe, Councilman Lee Sauer, but maybe not. We'll find out. And we have several items on the agenda today, but I do want to call out one out of order, just so that the folks on the hill waiting for it don't have to wait any longer than they have to. And that's item 10. My understanding is that the appellants have withdrawn their appeal, so I'm going to thank our Sergeant Dan Robbins and Detective Eric Moore. I know there's a lot of other things you could be doing as opposed to waiting here. So I want to make sure that I made you aware that the appeal has been withdrawn. I appreciate your hard work, everything you've done for our community, and I look forward to working with you in the future. But in this case, it's been withdrawn, so we don't have to be waiting here any longer. So thank you so much.
Councilman Jerry Birch with the City Attorney's Office, we would recommend that you take an action on that matter. Generally, that would be to deny the appeal in light of the fact that they have not timely withdrawn their appeal per our code.
Okay, so I'd like to make a motion that we deny the appeal. It's been seconded, there'll be action on this committee. Thank you very much. Okay, so let's just go through the agenda. And we'll call those special that have submitted cards. So we have cards in item 1. Items 2 through 8 are all on consent. And I don't see any cards for any of those items. So we can move approval on those on consent. Have a second? Thank you, sir. On number 9, we'll call special. 10 we just dealt with. 11 is special. 12 and 13. My understanding is that Director Goldberg will not be here for the oral report, so I thank her for her hard work. On 15, I don't see any cards on 15. Now, is that closed session? And so 16? Okay. All closed session items. So that takes us back to number 1, I believe, Roberto?
Yes, Councilman.
Okay.
Yeah, it's a motion, Parks LaBranche. It's requesting city attorney and planning to prepare an ordinance relative to prohibiting tobacco sales near schools.
Okay. So we can adopt that motion. We do have a card on that one, I believe. Before we take action, we have with us Steven Gallegos, Wes Wiedemann, I apologize if I don't pronounce your name correctly, and Janice Chow Ing. Good day, sir.
Good afternoon, Chairman Reyes, members of the committee. I'd like to first say welcome to the newest City Councilman, Paul Krikorian. Sir, it's an honor and a privilege to be able to have you here on the LA City Council, and this will be my great privilege to offer my testimony to this committee. My name is Steven Gallegos, and I'm the chair of the Coalition for Tobacco-Free Los Angeles County, coalition of about 120 community organizations and individuals who are working hard to prevent undue tobacco use by minors and to protect people from influence of secondhand smoke. Cities have passed tobacco retail license ordinances see the majority of the illegal sales of tobacco to minors occur around locations and venues they frequent. Sales of tobacco products to minors is against the law and has been a law in the state of California for over 100 years. Over 10 years ago, this Los Angeles City Council passed an ordinance banning tobacco product advertising on billboards that were placed 1,000 feet from where children congregate in order to stem the influence and allure it presented to minors. Tobacco product advertising has moved to storefronts and is visible inside convenience stores where tobacco is sold. Establishing a minimum 600-foot distance between stores that sell tobacco and locations that children frequent is a beneficial policy that will inhibit any undue influence the tobacco industry's beckoning messages and images may use to promote their products and its use to minors. We ask for the support of this committee for this motion and to get your vote. Thank you very much.
Thank you, sir. Our next speaker.
Good afternoon, honorable committee members. My name is Wes Rudiman. You got it pretty close there. I currently serve as the Director of Community Programs for Day One. We're a local nonprofit agency that deals with substance abuse prevention. I'm here today because my agency has conducted a number of undercover tobacco decoy surveys to determine if retailers are in compliance with the law. Unfortunately, the state has failed to adequately monitor these stores, which is their task, and that's why so many cities have passed local licenses. Of those cities that we've done surveys in, we've registered illegal sales rates of anything to 20 to 50%. I'd like to share with you one in particular. Last year in the city of San Gabriel, we found that 33% of the stores were willing to sell to a 15 or 16-year-old minor. Of these retailers, 92% were within walking distance of the school. So almost all of them, only one store was not within walking distance. And we measure it by 1,500 feet. So, many of those were much closer though. However, even more troubling, one of the stores, a tobacco shop, offered to sell one of the youth who's 15 single cigarettes. And that happened after the standard protocol is they state, we don't have enough money with us to buy the full pack. And when that happened, this clerk was like, oh, well, how much money do you have? I'll sell them to you for $1. Basically, our experience has been that, this is a problem, particularly close to schools. We thank you for considering this issue today. It's an important one.
Well, thank you for taking the time. Jonathan? And then we'll have Robert Navarrete representing State Senator Alex Padilla. Good afternoon, ma'am.
Good afternoon, members of council. My name is Janice Chow-Ing with the American Cancer Society. Cigarette smoking causes about 85% of lung cancers, but despite the known harms and the fact that children legally cannot smoke, every day 3,500 children will try their first cigarette and more than 1,000 children become regular daily smokers. To protect children from a deadly habit and the cancers it causes, the American Cancer Society supports policies that restrict youth access to tobacco products. Numerous research studies have found that making cigarettes as inconvenient, difficult, and expensive as possible reduces the number of children who try to regularly smoke cigarettes. Restricting the number of tobacco retailers near schools is an emerging tobacco control youth access policy strategy. Studies have shown that the more tobacco retailers there were surrounding a school, the more likely underage smokers were to buy their own cigarettes. Also, the prevalence of smoking was higher at schools and neighborhoods with the highest tobacco outlet density than in neighborhoods without any tobacco outlets. Further, schools are an important venue for instituting tobacco control policies because the vast majority of all smokers begin before high school. The American Cancer Society supports efforts to restrict tobacco sales near schools in order to reduce youth access to tobacco. In 2009, the Society supported SB 601, sponsored by Senator Padilla, which would have prohibited tobacco sales within 1,000 feet of a school. Although that bill stalled in the legislature, pursuit of this policy continues at a local level. Thank you.
Thank you. Mr. Navarrete. Is it familiar face? Good afternoon,
Good afternoon, council members. Wanted to read a letter for the record from on behalf of Senator Alex Padilla. I write in support of agenda item number 1 on today's Plum Committee agenda, which instructs the city attorney to draft an ordinance in consultation with the planning department to prepare and present an ordinance that prohibits the sale of tobacco near schools in the city of Los Angeles. Each year, 36,000 California kids become new smokers, and 75% of them will go on to become lifelong smokers. Tobacco use remains one of the leading causes of preventable death in California, with 40,000 Californians dying each year as a result of tobacco use. Costs associated with smoking-related diseases in California amount to nearly $16 billion annually. As the largest city in the state, Los Angeles bears the largest burden of these impacts. Surveys continue to confirm that the closer a tobacco retailer is to a school, the more likely they are to sell to children. A 2004 study by the Tobacco-Related Disease Research Program found that 33% of tobacco sales to minors take place within 1,000 feet of a school. In the fall of 2009, City Attorney Trutanich announced the suspension of 24 retailers, tobacco retailers' licenses due to repeated sales of tobacco to minors. Most of these violations took place near schools. By prohibiting or restricting sales in the proximity of schools, we can significantly reduce tobacco access to children. Dozens of cities throughout the nation have already prohibited or restricted tobacco sales in close proximity to schools because they realize the public health risks. The proposed tobacco control ordinance before you today will serve as a powerful tool in protecting the health and safety of children in Los Angeles. Thank you in advance.
Thank you, Mr. Garrett, and please give my best to the senator. Thank you for his hard work and his due diligence and proactivity on this issue. So thank you so much for your time as well. Thank you. Okay, that covers most of all of the speaking cards. And Councilman, you have any comments on item number 1 before we act? Okay. So I'd like to move to adopt this action. And a second. And then the action of this committee. Okay, back to the next item.
The next item, council members, is an appeal by Ricardo Icaza from the United Food and Commercial Workers Union. He's appealing the decision of the Planning Commission, which disapproved a general plan amendment, a zone change for the proposed construction of 30 townhomes in 4 buildings in CD 15.
Okay, before we get started, I understand Councilmember Hahn wanted to speak on this item, and I don't see her in the audience. And any of our deputies here present in the chamber? If I don't see, why don't we do this, because she did offer, and she wanted to speak at this hearing. Why don't we move to the next item, and we'll come back.
Okay. The next... What's his name from?
You don't have to send it right now. You can have your staff look at it. Oh no, this is from last time. I'm sorry? Does she want to speak? Okay, we'll do that. Okay. All right, next item, Roberto.
That will be item 11, council members, and this is an appeal by the Camarena Recycling, I guess, Center. Benjamin Camarena is the owner, and Franco Jacio is a representative. They're appealing the action of the Planning Commission, which denied a CUP for a recycling buyback center in CD9.
Okay, can we have the staff on this one? Okay, I'm sorry, sir. Let's get the staff first to give their presentation.
Yes.
No, can I ask you to sit down? I'm going to have the staff.
Oh, the staff is okay.
Thank you, sir. Good day.
Good afternoon, Mr. Chairman and council members. This is Faisal Roble, Planning Department. This was a CUP under Section 1224U22 that requires such projects to observe certain conditions, and those conditions have not been fulfilled. In an MR zone, a recycling is required to observe a 1,000 distance separation from any RUs. It's also required that it has to have also the same distance separation from a C zone. Those conditions have not been satisfied. So because of that, and because of the proximity of the project to the property line, which requires a 10 feet property line separation, which is now, according to this project, only 4 feet away from the property line, the project fails to satisfy these conditions under the municipal code, and staff recommended disapproval of the subject application.
Okay, so Can you repeat the last sentence? I didn't hear it very
The
clearly.
last sentence is that the location of the buyback building should observe a 10 feet separation from the property line, that the project should be 10 feet away from the property line, and this one is located within 4 feet of the property line on one side of the street,
So the codes and the standards are not being met.
10 feet.
So they are not being met.
They're not, yeah.
Okay. Anything else? Any questions, Councilmember? No questions? No? Okay, thank you, sir. We'll hear from the panel, Franco Jasso.
My name is Franco Jasso, and I'm representing Mr. Camarena, who is appealing to the entire decision. Oh, excuse me. Okay, sorry. My name is Franco Jasso. I'm representative for the applicant, Mr. Benjamin Camarena, who is appealing the entire decision taken by the City Planning Commission denying a conditional use to allow recycling buyback center for the deposit of the glass, cans, papers, plastic, beverage container, and similar recyclable materials in the MR1, located in 1051 East Slauson Avenue. The case CPC 2008-4814 CU was brought to the consideration of the City Planning Commission at its meeting on September 10, 2009, and the following action was taken by the City Planning Commission. Deny a conditional use to allow recycling buyback center for the deposit of the glass, can, papers, plastic, beverage containers. Did not adopt mitigate negative declaration. Adopt the finding contained to the staff recommendation report. As a representative, Mr. Benjamin Camarena, owner of Camarena Recycling Center, I respectfully request to the members of the Plan Committee to approve the conditional use to allow recycling buyback center. And number 2, adopt the mitigate negative declaration and reject the findings contained in the staff recommendation report. I wish to clarify about the finding in which the Planning Commission outlined the following issues. The location of the project will not be desirable to the public convenience and welfare. The location of the project is in an area desirable to the public convenience and welfare. I offer to opportunity to people and neighborhood to recycle and keep clean the area. B, the project will not be proper in relation to the adjacent uses of the development of the community. The proposed project will be proper in relation to the adjacent uses and in the development of the community, because the area is primarily of industrial and commercial use and did not impact directly to residents of the area. C, the proposed project will be materially detrimental to the character of development in the immediate neighborhood. The proposed project is not materially detrimental to the character of the development in the immediate neighborhood, given the business that they operate in that portion of the East Lawson Avenue. D, the location of the project will be materially detrimental to the public welfare. Sorry.
No, please continue. Go ahead.
Excuse me?
You can finish.
Okay. Yeah. No, I try to turn off. Okay. Sorry. Okay. The location of the project will be materially detrimental to the public welfare, injurious to the properties, and improvement to the affected community. The location of the project will not be materially detrimental to the public welfare, injurious to the property, or improvement to the affected community, because the recycling center is similar to the kind of the business that operate in the area. E, the proposed project will not be in harmony with the various elements and objectives of the general plan. The proposed project will be in harmony with the various elements and objectives of the general plan in the sense that the owner will comply with conditions and add elements of compliance, like enclosing the operation and adding space. members of the committee. If the finding, there is a reference to the CUQ findings, a mitigating negative declaration was prepared for the proposed project on the basis of the whole of the records before the lead agency, including any comments received. The lead agency finds that with imposition of the mitigation measures described in the mitigation negative declaration, there is no substantial evidence that the proposed project will have a significant effect on the environment. The attached mitigation negative declaration reflects the lead agency independent judgment and analysis. The records upon which this decision is based are in the environmental review section of the planning department.
So you're almost finished?
I have more.
Okay.
Regarding the 10 feet, I can do something. This mobile recycler, we are mobile recyclers. He's talking about the 10 feet separation, is no problem. We can move more than 10 feet if necessary. And the other thing is in negative declaration, they're talking about the hazard materials. We don't receive ni collect any hazard materials.
Okay.
The other point is in mitigating declaration. This is aesthetic. We can comply with aesthetic conditions because we could put the landscaping in the front and the block wall.
How long have you been there?
How long is it?
About 2 years, almost 2 years.
How many?
Almost 3 years.
3 years? Okay.
And I have some pictures for exhibit I want to show you.
Go into the clerk, please. We can pass them around. So you want to summarize? You want to finish?
Yes, sir.
Please.
Almost finished, yeah. I want to add something. I want to refer to the conditional approval that the owner is willing to accept in order to operate recycling center. Every condition that's to mitigate these conditions, the owner agreed to comply with them.
Thank you, sir.
You're welcome, sir.
Let's have anything else?
No, I'm just, all I want to say is think about
Can you
that.
come to the microphone, please?
I'm just want to, my name is Benjamin Camarena, and I'm just want to let you know that there is many recyclings on this over the same area, and I can comply with any requirements that you give me, and I just want to work. That's all I want to do. Give my workers, his family is making money, and keep working. That's all.
Thank you.
Yeah.
Okay, is the council office here? A representative, like to come on up, please?
Hi, Marie Rumsey here on behalf of Councilmember Jan Perry, and Council District 9 is in full agreement with City Planning's recommendation, and we ask that you deny the appeal.
Now, can you give me more insight as to the case here and
Yeah.
what's motivating your decision?
If you look at this map, it's this is Slauson right here. This is the side, the north side of Slauson that has the right-of-way on it, where Metro's looking at doing a light rail right now, or maybe heavy industrial. This is manufacturing right here. This is where the recycling center is, and then this is housing directly behind it. So you basically have housing that's looking onto a recycling center with some other kind of more enclosed industrial uses. This one is particularly tough because it's all outside. And so the neighborhood has complained about smells, sounds, heavy trucks coming in and out, those kind of issues.
So it's really a classic conflict of uses adjacent to each other.
Yep. This is a really tough area. The right-of-way makes it more challenging because you have about, 10 feet wide where it's just abandoned land. A railroad track runs down it maybe once a month. But this is kind of the side of Slauson where we're trying to update the industrial uses and transition more to commercial, so it's more friendly to the residential, and it's something that we're looking at in the Southeast Los Angeles Community Plan update to rezone this area to match if it, the houses are going to stay.
Right.
Yeah,
Okay.
it is a tough area, though. It is.
Okay. This evolved before planning was even in place, I believe.
Uh-huh.
Okay. Well, thank you very much. I understand the challenges for the appellants, but given the statements made in the council and the harsh realities of the conflict in zoning here, I would move to deny the appeal filed by Benjamin Camarena and his representative. Councilman Corey, is there a vote you want to take on this, your position? Do you have any questions from the staff? So we're moving to deny the appeal. You have a second? Okay. So that'll be our action as committee on this item. Our next item, Roberto?
I believe that we're still waiting for CD 15, right, Councilman?
Are we still waiting?
Yeah. Okay, so let's go to item 12 and 13. I believe they're interrelated. They're separate appeals. 12 relates to the MMD and the adequacy of the MMD. It's for a 146 apartment building. The issue here has to do with the density bonus that was granted, and item 13 is separate appeals as to the project itself, and it's in CD2.
Okay, let's hear from the staff. Please introduce yourself.
Good afternoon, council members. Savannah Mayulian with the Planning Department. I will give you a brief summary of the project. On May 8th of 2009, the Director of Planning conditionally approved the following: 146-unit apartment building with a total floor area of 143,578 square feet. Project will be a 4-story building with 1.5 levels of subterranean parking. The total number of allowable by-right units is 109. However, a 35% density bonus would allow for an additional 38 units, but the applicant is asking for 37 units. The project will reserve 11%, 12 units of its pre-density bonus units as restricted affordable units available to very low-income households. The total maximum project height, excluding rooftops, mechanical, and stair elevator shafts, is 48.7 that was approved, which is 35% increase allowed in lieu of the 36 feet based on the specific plan in Valley Village. Now, an appeal was filed in June 2009, and on October 22nd of 2009, CPC denied the appeal and sustained the DIR by placing one condition on the project, which was lowering the project height from 48.7 to 45.7, a total of 3 feet on 3 sides of the building. Overall, based on a compatibility study done by applicant and the staff, the height of the surrounding buildings in this project area ranges from 25 feet to 50 feet. And this makes the project compatible based on our analysis for the area. Thank you.
Okay. We're going to have several cards on this item, and Mr. Cocoon, yes.
Councilman, what about the appellant? Do you want to hear from the appellant?
Yes. From the appellant, please, come on up. Okay.
Doing 12 first, or we
No, both together.
both together? Okay.
Madam Attorney, that's okay, correct? Yes.
Mr. Chairman, if we are going to consider matters 12 and 13 together, I wonder if the appellants might be allowed a commensurate amount of additional time so that they can respond to the complexity of the issues of the two matters.
No, I typically allow the appellants to speak their piece in their case, because we want to know why they're appealing.
Okay.
So that is the role I usually take.
Very good. Thank you, Mr. Chairman.
Okay.
Thank you. Kerry Braisman, LA Neighbors United, a former executive with CB Richard Ellis, and a volunteer with the National Low Income Housing Coalition. I'm going to hit the environmental first because it's our hope that you all will see fit to order the Planning Department to do an EIR on this project before we consider any project approvals. But I'm also going to address the incentive issue in the event that you see fit not to order an EIR and you decide to rule today on the height incentive. So first, the M&D issue. Let's see here. I should note that I support affordable housing, including inclusionary housing. I helped bring a workforce housing project to my neighborhood, and I live near a very lovely tax credit project. Both of these projects are neighborhood compatible and supported by infrastructure. The Magnolia project, however, in combination with other projects underway or planned in the neighborhood, is not. Our appeal, which you have, documents the full extent of the flaws in the MND, including the net loss of affordable housing, the failure of applicant to provide full tenant relo assistance to former building occupants, the fact that the traffic study, we believe, was reverse engineered to avoid recognizing critical impacts, including at Magnolia and Laurel Canyon. It understates daily trips by 67%, and there are questions about the sufficiency of proposed mitigation measures at certain intersections. There's also inadequate infrastructure and public services to support the project, including incomplete sidewalk and non-existent crosswalks. And as anybody who got this week's copy of the California Real Estate Journal saw this week, at the breaking point, Valley Village sinkhole swallows fire truck not 4 blocks from this project. And I have no doubt that even Judge Yaffe would be moved would be moved by that. We've also learned of other planned projects not considered in the city's traffic study that would exacerbate cumulative impacts, and for these reasons we ask that the council deny adoption of the MND and require the planning department to perform an EIR on this project and cumulative impacts before any project approvals are granted. To address the issue of the height incentive, we submitted today pro forma table number 2, which you should have copies of from Seifel Associates. It's the contention of experts we've consulted that neither the height incentive nor the density bonus requested by the applicant are necessary to make delivery of the 12 affordable units economically feasible. This is documented in the table to which I referred. The design feasibility was affirmed by Ovalle Architects. The applicant, as Savannah said, has asked for a total height incentive of approximately 45, or a height incentive of 9 feet. The applicant, at least as of now, has not provided any economic rationale supporting the need for a 9-foot height incentive. Today we submitted pro forma table 2, which demonstrates that a 146-unit project can be constructed within a 40-foot high building envelope, generating attractive economic returns for the applicant and still allowing the applicant to have a 10-foot high ceiling on his 4th floor and or approximately 9-foot high ceilings throughout the building envelope. Clearly, by this evidence, the applicant does not need a 9-foot height incentive for the project to be economically feasible, and nothing in state law, as the city attorney can tell us, either directly or by implication, precludes the city from granting an incentive request in part or outright denying an incentive request if it's not needed to make the project economically feasible.
Can I ask you one question? In terms of the size of the units, and trying to determine in the table,
Sure.
What's the relative size? Am I not seeing it, or is it not here?
It's there, and the size of the units as we propose in Alt Project 3 are the exact same size. It's the average square footage as the applicant has proposed in their project.
Exact same size, okay.
So just to sum up again, if we're hopeful that today the council will see fit to order an EIR on this project based on outstanding issues relative to the MND. But in the event that you don't see fit to order an EIR, we urge you to approve a 4-foot height incentive based on this evidence with some allowance for architectural elements or schmaltz, as we say, above the roof line, so the building is more compatible with the neighborhood, including the Valley Village specific plan. Thank you.
Thank you. This is part 2 of the appeal, right?
This is part 2.
Okay.
I'm doing actually agenda item number 13. My name is Sandy Hubbard. I live at 11911 Magnolia Boulevard. You have received a plethora of material from us. I recognize some of the binders in various locations, so I won't rehash it all. But the points that I'd really like you to focus on outside of the pro forma, which the community commissioned to prove that in fact this building did not require the additional height incentive. We want you to take a look at the underlying zoning. This is something that should have been addressed from the get-go and was not. The zoning is wrong. It was an AB 283 miss. It needs to be downzoned. Why is that important now? because your by right unit configuration is false if you don't address the zoning issue. Secondly, the clarification is needed very specifically as to what government code this project applies under. We've had a shell game that has been played with the community as to whether or not government code by the state is the only code that applies, or whether or not the city's density bonus ordinance applies. We received 3 different notifications between April and May trying to determine that very fact. In May, as you heard Savannah mention, she did finally send a mailing out to us that said the city's density bonus ordinance did not apply. However, if you take a look at the DIR that was issued by the CPC, it does apply. Therefore, if the city's ordinance applies, certain things had to happen with this project. It needed to have 1 foot setback around the building for every foot of height that was given. So it's appropriate to determine specifically what code applies here. Additionally, the applicant's application was not deemed complete until March 2009. Because of that, it does determine whether or not it is grandfathered in under the provision that City Council had requested to allow projects that were near completion to be let through without having to apply to the newer onerous rules. The reinstatement of previous conditions that were given on this particular project. This is a subject that neither planning nor CPC were willing to hear us out on. We requested a series of conditions when we worked with this particular developer on the condo project that he initially envisioned on this site. All of those conditions were valid as they related to paying out to previous tenants relocation fees. They had to do with safety matters like no left turn out of the garage that would help, just very basic rudimentary conditions. He agreed to them then. They need to be reinstated, especially the tenant relocation fees. Therefore, we request that you would refer this matter back to planning, that the property be downzoned, that you require a full EIR that would study the traffic study that was erroneously produced and the necessity of the height incentive, that you require that the current site plan review be done on this project, not on the condo project, that you require that planning make the code clear as to what government code this applies to, that you require that the ministerial action that was granted for the VTT 67012 M1 action of allowing the 78-unit condo project to ministerially and mysteriously suddenly become 148 units of condos be shelved. This should not be allowed to proceed without any kind of community input. Thank you very much.
Thank you, ma'am. I was just thinking to Councilmember Hahn, I know she's here, and want to acknowledge you, but the fact is, we started this case with a few speaker cards, so I don't want to keep you waiting too long, but we'll get to your case as soon as we're done with this one, because we're combining 2 cases in one session. So, but welcome to the chamber. Okay, so we've heard from all the appellants. Is that all, Roberto?
I believe so, Councilman.
No. I'm just asking if we heard from all the appellants.
Hello, I'm Jennifer Reed, 11911 Magnolia Boulevard. Thank you for listening.
Good afternoon.
I am speaking again to the zoning and AB 283 criteria. We have done all the research. You'll see it in the notebook you received specifically on zoning. There is plenty of material for the planning department to admit that an error was made and a correction is appropriate. 3 times planning looked at the land use of the immediate area of this project in our recent history. 3 times sub-areas were numbered and created. 3 times examiners recommended RD 1.5, RD 1.5, and finally R3 for the sub-areas created. Never did they recommend R4. All the frontages of Magnolia and Chandler were downzoned. Criteria for AB 283 General Plan Zone Consistency Project in 1985, in a case 85027 CPC stated where a sub-area contained multiple zones, each zone was to be reviewed as separate sub-areas. We have Full documentation, no more is necessary except to look at the full documentation. The specific error, the failure to create a specific subarea for the Magnolia Boulevard frontage between Radford and Ben Avenues justifies and supports a downzoning now for the project site before you for consideration. As you have heard, the same two-story multifamily buildings still exist on those parcels, built in 1952 and 1953. The frontage of Magnolia was primarily RD 1.5. There were never any R4 buildings on them. There is no R4 zoning in any of the residential sub-area 5400 that wasn't downzoned to R3 or less created. There is no R4 zoning in all of Valley Village west of the 170 freeway, in fact, in all of North Hollywood Community Plan, except for a school and church zone and a pre-built building. The building that Savannah mentioned earlier about something being 50 feet, that was an illegally built building across the street above the 45-foot height zone and was the reason for the Valley Village specific plan. So to use that as a, the character of the neighborhood would be erroneous. Regarding the zoning and the code, this full specific answer about the code it was determined under, there was a 325 application filed that was completely deficient, required a new master land use application to be filed, which was not done until a year later, 3309. The applicant and planning did not require them to show economic need for the concessions. It skirted the requirements of the LA enabling ordinance, and simultaneously they are also relying on this incomplete and defective application with endless errors and misstatements to claim their prize, which is an outsized, dense 146 apartment building. And they are also used a special revised menu in this revised planning application, which does not list the same menu incentives as the housing department's menu nor the enabling ordinances menu, despite the fact that this revised menu was dated 1509. Thank you for listening.
In terms of the, you spoke of the structure across the street. I was there last night and I got there right before sunset, and when it got dark, I wanted to understand the traffic flow and impact. But you do have a relatively new structure right at the corner that I believe is about 4 stories high.
4 stories, 36-foot height limit of Valley Village has been observed.
Okay. So
it is within the Valley Village specific height plan.
Okay. But your assertion is the one across the street was built illegally?
Illegally.
Okay.
It was at the time pre-Valley Village specific plan. It was a 45-foot height limit. It was built at 50 feet.
Right.
And that was illegally done, and the city did not do anything to change that.
And as I drove down the corridor, I saw several structures at 2 stories, 3 stories, 4 stories.
You will only have found one that was 4 stories, and that has been built to the 36-foot height limit. The 4-story illegally built one is the only other building you would have seen. Everything else is 2-story, and everything else is within the correct character, the neighborhood character, underneath that 36-foot height limit, which people struggle long and hard to get into their specific plan.
Okay. Thank you, ma'am.
Thank you very much.
Now, I'm going to go through the cards now, unless you're identified as an appellant on record. If you're not an appellant on record, okay, please go on.
Honorable Councilman, I come before you with sincere gratitude that you have agreed to review this project. The community has followed the rules of the process and put forth legal arguments over and over why this project requires major revision. Thus far, our efforts have been discounted. I know you have all received the appeal, and I will not detail every legal argument in 2 minutes that would allow legal findings to be made to uphold the appeal and request for a full EIR. Despite conversation to the contrary, the project for review is discretionary. The number of units proposed and the incentives granted are not by right. There are those who are interpreting the law to state the applicant, in effect, has a by right project. However, that is not what the written words of the law state. I do not believe the planning department or legal staff is either evil or ignorant of the law. They have been given a direction to follow and are applying and interpreting the law to follow that direction. What is required now is a change in direction, and that can only come from you. I understand fully that we are imploring you to do is right the direction of the ship. We are at a critical juncture in the history of our city. We need our elected officials to be statesmen and do what is right, not what is easy. The problems with the project start with the zoning. This parcel is an obvious AB 283 miss, and there is no justification for it to retain its present zoning classification. Months and months of research have been painstakingly compiled and laid out for staff and the city council. If this were a case for upzoning, it would be done before AB 283 could be uttered from my mouth. The community also provided 3 professionally prepared performers that proved the density and height were not needed to have an economically feasible project with 12 very low income units. This project replaces 51 affordable units with 12. The CEQA issues that require full EIR have also been detailed for you. An independent professional traffic report had been prepared that delineates the flaws in the Hirsch Green and the LA DOT traffic reports. Magnolia Boulevard is a substandard secondary highway. It will remain a substandard secondary highway for the foreseeable future, no matter what mitigation measures are employed. The street cannot sustain the present level of traffic even without tripling the density of projects in this corridor. Even in the LA DOT report, it stated it was relying on cut-through traffic into the single-family area south of Magnolia to facilitate traffic flow, where 4 of the 6 intersections studied already had an LOS of F. The single-family area that LA DOT suggested has no sidewalks, and all the streets are substandard. All of these issues were just a fraction of those detailed in the appeal, even though LA DOT underrated the trips generated by this project by 67%. The community also, I'll be very fast, the community also procured a professional shade shadow report. This report proved the project violates the CEQA threshold for sun-sensitive recreational land uses of neighboring properties. The staff report stated the project did not violate the standard for the neighboring rooftops. That is not the issue. The city has undertaken a water rationing program this year due to the lack of adequate supply. The wisdom of tripling the density of property must be evaluated fairly, judiciously, and exercising common sense in light of this fact. The infrastructure is also experiencing extreme stress with regard to water mains rupturing, sinkholes, and the capacity of sewer lines. Just adding density without proper thoughtful consideration is again foolhardy. A full EIR is needed to fairly evaluate the significance of these issues on the environment. The issues I have raised in these comments are just a small representation and have been briefed to conform with the time limits. I believe they prove legal findings can be made for a full EIR and to uphold the appeal. The most disrespectful action you can take for the community is to reply, the state made us do it. Again, I wholeheartedly appreciate and thank you for your consideration. And my name is Dale Leibowitz-Neglia, and I want to let you know...
I'm sorry, your name is again?
Dale Leibowitz-Neglia.
Okay.
We have 17 NCs and community groups supporting our appeal, and we only have 17 because we ran out of time to visit more neighborhood councils. The appeal has broad citywide support.
Okay. Now, before the next speaker comes out, because I want to call the appellants first. Who's the appellant on Mike Roberto? Because I want to make sure that we have the folks coming in.
For item 12, Councilman, is Carrie Braceman. And the second appellant is Sandy Hubbard. For item 13, the appellants are the Magnolia Tree Villas Homeowners Association, and there's a Jennifer Reed, Sandy Hubbard, and the Reddington Plaza Homeowners Association.
Okay.
There's also Daryl Neglia, who I believe she just spoke, and a Jennifer Reed as a representative, and also the members of the board of the Neighborhood Council Valley Village, and then Anthony Braswell is mentioned as a representative.
Okay, so those are all the appellants.
Yes, Councilman.
Okay, so let's hear for the next one. So what's your name, please?
We're united. Okay. My name is Sarah Bolton. Good afternoon. And I am, thank you. I am the president of the Weddington Plaza Homeowners Association, 11910 Weddington Street. Our building abuts the proposed 146-unit project to be built on Magnolia Boulevard in Valley Village. I'm here today to show how this project directly violates the City of Los Angeles CEQA Thresholds Guide for Shade and Shadow. The CEQA Guide states the importance of routinely usable outdoor spaces associated with residential and recreational land uses. These uses are considered sensitive because sunlight is important to function and physical comfort. The guidelines also state a project impact is considered significant if shadow-sensitive uses would be shaded by the project for more than 3 hours between 9 and 3 from fall to spring, or for more than 4 hours between 9 and 5 from spring to fall. At the CPC hearing last October, in the Planning Commission's PowerPoint presentation, the slides during the shade-shadow part were not accurate. The correct aspect ratio was not projected, and the slides that were shown were either horizontally or vertically elongated. The plans that were approved at that hearing show that the rear setback of the proposed structure to be 16 feet. What that means is that there will be a more than 48-foot structure that will abut our pool area and backyard and will completely block any sun into that area for all of the year, thus violating the CEQA guidelines for shade and shadow. The rear setback of the current structure that is there is over 40 feet because it includes a one-story garage and flat parking area that will be omitted in the new structure for underground parking. We are asking that the developer increase the setback of the proposed structure to a total of 30 feet so that our backyard and patio and pool area will not be plummeted into darkness. We are currently surrounded on the south, on the east, and on the north with structures. Our only access to sunlight is from the west, and it will be completely blocked by this new structure. What is the use of demanding maximum open space allowable per unit, which is 100 square feet, when it eliminates entirely the open space per unit of the adjacent properties? Thank you. That's all I have to say. I do have a couple of photographs of our backyard. You can see where the proposed structure will be and how it will completely block our area.
Thank you, ma'am. Any other appellants before I move on to the public comment? Okay, thank you. See no other appellants? And hopefully, you just state your name, your address. So we've heard from Jennifer Reed, is that right? Okay. And then we heard from Kevin McDonald. No, come on up, Kevin. And then we'll start the...
Good afternoon, council members. My name is Kevin McDonald of the law firm Jeffer Mangles, Butler, and Marmoro, representing the current owner of the property, First Regional Bank. I understand we're combining items 12 and 13, so I'll do as the other speakers have done and start with the CEQA appeal. The appellants primarily rely on what is known as the fair argument rule to refute the MND and call for the preparation of an EIR. What's important to understand about the fair argument rule is that it's not merely enough to present an argument. You must support that argument with substantial evidence in the record, and that has not been offered here. Most of the issues that were raised in the written materials are wholly irrelevant to a CEQA analysis. CEQA seeks to analyze the impacts on the physical environment. So these issues about site plan review, the zoning, relocation assistance, all these things are wholly irrelevant in that analysis. They attempt to discredit the approved traffic study that was approved by the Department of Transportation by presenting a letter from another traffic engineer. However, that engineer also doesn't provide any new evidence to support some of the comments that he was making. He attacks some of the assumptions that were made. He offers examples of what other jurisdictions may be doing, but he himself, as an expert, doesn't provide any evidence at all to support his opinion, and that too would not rise to the level of substantial evidence required by CEQA. Given that the MND has been properly done, is itself supported by substantial evidence, is not refuted by any substantial evidence to the contrary, it should stand as approved by the City Planning Commission. Quickly moving over to the Charter Section 245 appeal. First of all, we submit that that action by the city planning, or excuse me, the city council is time barred. The action of the City Planning Commission was taken on October 22nd, 2009. Charter Section 245 allows for bringing the issue up before the City Council within 5 meeting days after the action is taken. The 5th meeting day was November 3rd, 2009, and it wasn't until January 12th, 2010 that City Council moved to assert action in this matter. If you decide to go forward with that action, of course you must look at the merits of anything that might be done to disturb the City Planning Commission action. And again, at that hearing, there was a lot of discussion that you heard today about a lot of issues that were raised very early on in the application. But it's important to note that the City Planning Commission's review and the City Council's scope of review similarly is limited to just whether the single on-menu concession of height is needed to supply the additional units.
Okay, I need you to summarize, and my apologies, but you'll have the clock rolling on this one.
I will wrap it up.
Okay.
So, as was discussed at the City Planning Commission hearing, essentially what you would be doing by not granting the height concession would be to eliminate an entire story from this building. There's 146 units. You would eliminate at least 36 units from that building by eliminating that story. You simply cannot get 4 stories in a 36-foot high building. That concludes my presentation, unless you have some questions.
No, thank you very much. Next speaker, Bill Resnick. Lisa Sorkin, and Wise.
Good afternoon. Good afternoon, Chairman Reyes, Member Krikorian. Ben Resnick, for the record, with Jeffrey Mangles, Butler, and Marlboro. As you heard, we represent First Regional Bank. I wanted to also comment and just supplement my partner Kevin McDonald's comments, because I just want to remind the council, audience, and others, this is a case that's exactly similar to the case about a year ago that we handled, called Louise Apartments versus City of Los Angeles. That was a case in which, again, it was a height concession for a density bonus. The city denied that based on various arguments made by neighbors. The court was clear. The court granted the writ and indicated that the city was wrong in not applying SB 1818 and not allowing the additional height. And the end result was not only did the city lose, but had to pay all of our legal fees. I don't submit that the city council would like to revisit that issue in just within 1 year. The problem is that people just, I guess, are not coming to grips or understand what SB 1818 is really about. It's not about whether or not a project without it is economically viable. That's market rate housing. If someone wants to do it, that's fine. An SB 1818 project and the economic aspects of it go to the fact that if I'm going to provide affordable housing, I have a right to have the bonus and the concessions. In this case, this is a concession that's by right. It's on your so-called menu list of your own ordinance. It's within the limits of that. It's what the city vetted through for 2 years in adopting this ordinance. And so this application is within all fours on not only SB 1818, but the city's own density bonus laws. So deviating from that would really, I think, make a clear case for us and put the city in a legally untenable position, but more importantly is against public policy if we are to encourage people in this city to apply for SB 1818 projects, which is the only way the city is getting its affordable housing units on a geographically wide basis. And so I would ask that you deny the appeals in total and sustain the Planning Commission who vetted this through. Thank you.
I have one question for you, Mr. Resnick. On the case you cited, the one the city lost, in that case, were there more affordable units at the end of that process, or were there less on that site?
On that site, it was a much smaller project. There was only 25 units, and the added concession was a little bit extra height that even in that case did not generate more units.
It did not.
Did not. And so the court nevertheless said that because it's a concession that is within the allowable concessions, that and the city failed Similarly to this case, the city failed to have substantial evidence to show there were adverse impacts. That's why the court.
One question, Mr. Corn.
Thank you, Mr. Resnick. I do have a question. In the previous case that you described, were the allowances made pursuant to SB 1818 or the city's implementing ordinance under SB 1818?
That was under SB 1818, and I believe at that time it was the implementing ordinance still.
Okay. And in your comments, you mentioned the menu list, which is under the city's ordinance. Is that right?
Right.
So is it your position now that this project was approved or should have been approved under the city's ordinance or under SB 1818 without the benefit of the menu list in the ordinance?
I'm not taking a position on that issue. I'm not here to debate which way it goes, because whether you do it under the implementing ordinance or you do it under the city's ordinance, SB 1818 dominates. It is the preemptive ordinance. And this request falls within the SB 18 guidelines. I leave it as to whether or not you think it's the ordinance applies or the interim. I think either way, the additional height that is granted here in order to allow the units to be built, because without the additional height, you can't get the fourth floor, you can't build the density bonus units, and therefore you can't provide the affordable units, then no matter which one you apply, the interim or the city guidelines, I believe that that is mandated, and so
okay.
It doesn't matter.
The reason that I ask the question is because there apparently has been some ambiguity over the applicable law in this case, in that planning apparently relied to some extent on the ordinance, and your argument has made reference to the menu list, but it was my understanding that the project actually, at least it was the city attorney's opinion, that the project was prior to the effective date of the ordinance and applied only under SB 1818. And I'd like to get some clarification from planning or from the city attorney as to which is the applicable law, because I think it's a little difficult for the Planning Commission to have made a decision and for us to now rely on that decision without knowing whether it was based on the correct law or not. And I think that's why it's an important opportunity for us to revisit this issue pursuant to Section 245 and review the issue de novo if we don't even know what the applicable law was that this was decided under in the first place. So if we could get a response to that, Mr. Chairman, from either planning staff or the city attorney. The appellants mentioned that there was some ambiguity over this, and I'd like to see if we
Robert
can get it
Duane,
straightened out.
City Planning. This question has always come up, and we've always had the same answer. Yes, there was confusion in the beginning when the project was being analyzed, but it was clarified at the commission level. It was under the SB 1818 ordinance, not the implementing ordinance. The commission was informed of that, and that's what they took an action on.
Okay, so the menu list under the ordinance is irrelevant then to the decision on this project, because it wouldn't have applied if this decision is made only pursuant to the state legislation. Is that correct?
That's the one we used, right.
Okay, thank you.
Okay. Next speaker is Lisa Sarkin, and then I have my Weiss. Good afternoon, ma'am.
Good afternoon. Thank you. I think it was under the draft ordinance SB 1818. Certainly wasn't after the SB 1818 ordinance was passed, because it was not until 2009 that we had our own ordinance. Okay, I'm here for the Studio City Neighborhood Council, Lisa Sarkin, 11603 Kelsey Street. 13 neighborhood councils supported the appeal that was originally what we thought we were going to be talking about today. And for the Studio City Neighborhood Council, on June 22nd, we passed the motion. The Board of the Studio City Neighborhood Council supports the stakeholders of Valley Village's appeal, DIR 2008-1178 SPP, regarding the SB 1818 development located at 11933 Magnolia Valley Village. I've also been authorized to ask you to support Section 245 on this council file. Thank you.
Okay, Weiss.
Council members, good afternoon. I, like Mr. Resnick, I think have some standing here because I, like Mr. Resnick, also won a case against the city involving SB 1818, specifically knocking out two of the implementation provisions. So, in the city, and with the help of Doug Carstens. Mr. Resnick's characterization of that Louise case is wrong in terms of its applicability to this situation, and in fact, the facts are that they wanted 50 feet. They managed to build within the 45-foot envelope of an R3 what they initially desired to begin with. So the case, as far as I'm concerned, has no application. It dealt with aesthetics. Our case deals with economic feasibility. Economic feasibility is really important. And by the way, Mr. Reyes, I really appreciate the fact that you went out to see the property. My people are not NIMBYs. That property behind was basically accepted by the community, and we have an affordable housing covenant within that project that provides. So what we're talking about here is not, and under SB 1818, what we're talking about is the opportunity, the obligation of the person seeking the incentive or the concession to submit criteria or an economic pro forma which justifies the need and the desire for it. Because your own law, the state law, says that that the city has the right to deny the project if the developer doesn't need the incentive or concession to the extent desired, or the city or the developer or the community can negotiate for alternatives relative to meeting the need. We're talking affordable housing here. That's the goal. That's the criteria. That's the vision. And what we have is an implementation situation in this situation where we're destroying more affordable housing than we're creating. Mr. Resnick had to admit, even in the Louise case, that they destroyed more affordable housing. We can't do that. That is Orwellian. There's a principle. There's the reality. We are at the intersection of where reality meets the principle. What we're asking, what Mr. Kokorian's asking, is to apply consistent with the overall goal. And that means requiring this developer, sending this back to planning, requiring the developer to submit the kind of pro formas that are necessary. Burbank does it. Santa Monica does it. Berkeley does it. There's no reason why we can't do it here. Thank you, Mr. Reyes.
Thank you.
Councilman Kokorian.
Okay. Barry Johnson, and Michael Krivener, and Barbara Monahan-Burke.
Hi, Barry Johnson, Studio City stakeholder. I support the appeal. The city has not completed a report on growth and infrastructure since 1998 and seems to have little idea what is really happening in our communities. The continuous reports that you receive from neighborhood councils and other community groups are real on-the-ground reports from citizens. The city planning department has abandoned its job of planning the communities because they shove off all responsibility to other city departments to make the decision after the projects are approved or anything related to infrastructure. They use boilerplate language and conditions to mollify the reader and are trained in how to frame the language in these DIRs and recommendations to make the developer seem beneficent in their partaking of the feast. SB 1818 and the city's implementation of it now quadruples this, and now the planning department and the city seem to reject any responsibility for the impacts many of these projects have on infrastructure and the environment. Thank you.
Thank you. Next speaker. Barbara Monahan-Burke, Michael Krivener, I'm sorry.
Yes, thank you very much. Michael Krivener, I'm a stakeholder. I live at 11911 Magnolia Boulevard, directly next door, and I'm here in favor of the appeal. It was just... Thank you. Thank you very much. It was just discovered on January 14th, 2010, while preparing for this hearing, that within the December 23rd, 2009 CPC determination, item number 48 reintroduces the language that this project is approved under Government Code 65915 as adopted by the City Council on February 20th, 2008, and effective on April 15th, 2008. This clearly requires the project to conform to the city's density bonus implementation ordinance, as the ordinance at minimum requires that the following change, that the building should be set back 1 horizontal foot for each foot of height that exceeds the 36-foot VVL specific plan.
Thank you.
Thank you.
Ms. Burke, followed by Sulan Cruz, I believe. Good afternoon, ma'am.
Good afternoon. Barbara Monahan-Burke, Studio City Neighborhood Council. I support the appeals of items 12 and 13. I ask to downzone this property. It is important to emphasize that the city misled the community in the earlier track map cases involving Magnolia Boulevard between Radford and Ben because the city provided inaccurate ZEMIS computer record information. All the sites on this Magnolia frontage showed a consistent ZEMIS R3, R4 zoning, including an incorrect zoning of the Magnolia Tree Villas property site as R3, R4, when in fact it was rezoned and developed at RD 1.5 in 1980, prior to the time the AB 283 zoning consistency process was being completed. The ZEMIS record for Magnolia Tree Villa's property now shows the correct RD 1.5 zoning. I urge the Planning Commission, based on the evidence presented, to deny this application and refer the zoning matter back to the Planning Department, City Council, for appropriate rezoning of this site that is consistent with the existing legal requirements of the AB 283 mandates. I appreciate your attention.
Thank you, ma'am. Sweelam, I believe it's Cruz, right? Okay. Good afternoon, ma'am.
Good afternoon. My name is Sweelam Cruz. I'm a homeowner. Just want to share, I'm in favor of the appeal. I just want to share a couple of personal experience. In the past 14 months, I live on Magnolia. In the past 14 months, I got into 2 car accidents. One on the corner of Radford and Magnolia, and the other one just half a block down. I don't know if you're aware, but there's 2 high schools down the street. One North Halloween, the other Oakwood Private School. The other one was right in front of the school. I just want to say that I already feel like it's very unsafe there. High school students walk in front of Magnolia by the drove. If proper downzoning had occurred, the project on the corner of Ben and Magnolia would not be 97 units. It would be 39 units. So I already feel like it's already negligent that has already been built. So if this project gets built, you're talking about potentially 500 extra cars coming out from Magnolia to where these students are walking by. I'm a parent too, and I have a son who who goes to school 4 blocks away. I drive him because I think it's unsafe to walk in that area. So that's it. Thank you.
Thank you, ma'am. Tom Patterson and Michael Duke. That will conclude the public hearing. Good afternoon, sir.
Good afternoon. Tom Patterson, 5329 Vantage Valley Village. I was the person who was responsible for the Valley Village specific plan, and it was the consequence of the height of some of the buildings that you looked at. In the late 80s, there was an attempt to ring the single-family residential community to the south of this area with overheight apartment buildings, and we stopped that through the specific plan, and for the last 20 years, we've been successful with developers in bringing in affordable housing, new housing, up to a 36-foot height limit. The zoning issue was very much part of the appellate process. The Planning Commission the Planning Department directed the Planning Commission to ignore the zoning issues that were raised in the appeal. They said it wasn't relevant to their consideration. It's very relevant because it's the underlying issue here. I personally went to the city archives and spent weeks pouring through all of the documentation back into the mid-70s, and it's clearly evident that in the AB 283 process, the plan amendment that was proposed to retain this only black frontage of R4 zoning in all of North Hollywood west of the 170 freeway is not supported by any evidence in the AB 283 record. There's no explanation on why that particular frontage was retained in R4 zoning, and all of the criteria that was to have been used in the AB 283 process, if you apply it to that subsection, it's clear there was a glaring mistake made that unfortunately wasn't caught until 2008. It's time now to remedy that problem. The city has consistently, there's no statute of limitations. The city recognizes in the 2AB3 process, there may have been missteps and mistakes, and they still to this day make those corrections, and that's what we're asking you to do today. Thank you.
Thank you, Mr. Patterson. Michael Duke, and that will conclude the hearing.
Hi, my name is Michael Duke. I live at 11911 Magnolia, number 3. My townhouse is about, my kitchen window will be about 6 feet from the proposed monstrosity next to me. I'll be looking at it like this. And, you know, the fellow, we're going back to this dense, it's not just the height of it, it's the sheer mass of the thing that will be, that it will be with 146 units. Similar to the building that you looked at, the new one at Ben Street, you know, yeah, it was 36 feet in height, but you can see what happens when you take a R3 or R4 density like that in a building that height. It was, well, it's rectangle and it's, well, ugly, very ugly. And now for us, we're going to have the solution, says the petitioner, is we'll build a big, huge monstrosity that'll look nice, but big and huge. And now we're saying, hey, look, why don't we just have some common sense here and build and develop the way we should with, you know, with the proper infrastructure that we need. That's it. Thanks.
Thank you, sir. Can I have the staff come to the microphone, please?
Robert Duenas.
Thank you. There have been several assertions made about an illegal building. Is that building across the street, in fact, illegal?
I could not tell you if it was built illegally or not. I did not pull any records on that project.
Okay.
Staff hasn't pulled any records on that.
Okay. Now, when we talk about the commissioners and the vote they took, were they aware of the inconsistencies that are being brought out today in committee in their discussion?
Inconsistencies as far as the AB 283 zoning?
Right, all the assertions that are being made.
That was all part of their appeal. That was all presented to them by the appellants. They were made aware of that by the appellants. When we were at commission, we had to narrow down what their authority was, what was before them to act on. One point that's constantly brought up is the 78-unit project. That wasn't before them. That has nothing to do with this new development. This is 146 units of apartments. 78 units was a condo project the applicant applied for, went through the process, negotiated with the neighbors, the city, and at the end of the process was approved for something. We cannot say, whatever you approve there, we automatically apply here. We have to say, we're looking at your apartment project here, review it for its merits, its impacts, and come up with conditions.
Okay.
The two are kind of being intermixed.
Okay.
And with the AB 283 zoning, I unfortunately was old enough that I was part of that AB 283 zoning. Yes, it was a new process we went through. There are corrections being made today, to this date, to that process. However, I can take those reports, I look at them, but what I don't do is try to second guess what the intent was. Those were adopted by the full city council. I have to assume the council adopted this for a purpose. The errors I deal with are sometimes when an ordinance map is shown to me, and then I go out to the site and the ordinance map wasn't published. The old zoning is still there, we then correct it. Same with the plan amendments. But for me to say, well, I'm presented with an ordinance map, but it should have extended out to here. Or they really should have done this. I can't make that leap and say, I'm interpreting what the council adopted 20 years ago.
Right. Now, in terms of the affordable units, there's an assertion that we're going to be losing affordable units with this development. Can you speak to that?
When development does occur, the existing product on the ground is demolished, and this has been, even without this density bonus program, SB 1818, that assertion is made. A person comes in, you've got 5 units built on the ground in the valley. Person comes in, say by right they can build 20 units. They build 20 units, market rate. The original 5 could have been affordable, and probably were. They were market rate, smaller units. That changeover happens. But typically what happens is when you build that 20, there's no mechanism to require even one additional affordable unit. Everything goes market rate typically. However, under SB 1818, you do have that kind of mechanism where you can replace some of them. Not one-to-one, but at least something.
So, did we lose affordable units or didn't we?
I couldn't tell you what the rents were for those existing units that were vacant. Market
Okay,
rate.
well, what's the list?
But if they were affordable, yes, there is a net loss.
There is.
If they're affordable, yes, there's a net loss based on the numbers.
Okay. Any questions for the staff? Councilmember Krikorian?
Yeah, the respondents indicated earlier that it would not be possible for a project like this to be economically viable with 4 stories consistent with the Valley Village specific plan. But there are 4-story buildings on that same block that are within the 36-foot height limit, are there not?
I think there are 4-story buildings. Yes.
Okay, thank you.
Okay. Councilman, let me ask the city attorney this question. Thank you, sir. Thank you. I'd like to continue this item. There's detail here that I want to drill down. I want to read the commission report one more time and understand what the assertions have been. How much time do we have to kind of digest this a little bit better?
Jerry Burge, City Attorney's Office. You do have time to continue this 1 week in Plum and still meet the 21-day deadline for the council to act.
Councilman Krikorian, I know it's your district. I respect the fact that this is something that's very important, obviously, in your district. Would you mind if we continue this 1 week?
No, I have no objection to that, provided that we have confidence that the 21-day time limit will still be complied with. I know that the respondents indicated that the Section 245 motion was itself untimely. I think that's clearly not correct, and I think the city attorney would agree that that's not correct because the effective, the clock starts running upon the written notification of the commission's action. Is that correct?
That's correct, Councilman.
Okay. All right. With that, I have no objection then to continue holding this over until next week, Mr. Chair.
Just to be very clear, for the record, Madam Attorney, we did 245 this according to the rules.
Yes, again, Jerry Burge for the record, yes, according to the charter. We've actually advised that the council can assert jurisdiction for 5 council days from the oral action or the written action based on the language of the charter. Here, not both, either one. Here, you asserted jurisdiction from the written determination, and we think that's proper under our charter.
Okay. So, with the consent of the council member of the district, we can continue this 1 week. Again, give us more time to drill down on these issues. And I don't have any more speaker cards on this item, so we will continue this for 1 week. Thank you very much. Roberta, what's next?
And to be clear, you're continuing 12 and 13, Council.
Yes, 12 and 13, to be very clear.
The next item would be the CD 15 item, the appeal by Ricardo Icaza from the United Food and Commercial Workers Union has to do with the disapproval of a general plan amendment and a zone change for a proposed 30-unit townhouse in 4 buildings in CD 15.
I do have a council member was here, very patient. I'm assuming she's on her way down. Okay. Mr. Rausch, how are you, sir?
I am fine, Mr. Reyes. Happy New Year.
Happy New Year.
And as a resident of CD2, it's nice to have a vote back.
I don't think he heard you.
He's in 10. Okay.
Please. Go on, Mr. Rausch, and after you'll have the council member speak.
Okay. Oops. There we are. Good afternoon, Chairman Reyes, Councilmember Krikorian. My name is Charlie Rausch, Senior City Planner for the West Coastal Section and Planning Department staff on this particular case. What you have before you is a appeal of a case which was turned down by the Planning Commission. The case was a plan amendment to delete an MR1 designation. MR1 designates the restricted manufacturing zone, which is a more restrictive manufacturing zone. Designation from a property in the zone for planned and zone for light industrial uses in the Harbor City community. There was a concurrent zone change from the MR1 MVL zone to a CM zone. The MR zone does not permit residential uses. CM zone does permit residential uses. The proposed project is a demolition of the existing union hall and the construction of a residential project containing 30 townhomes, townhome units, and 4 25-foot-high buildings. The entire site would have been limited to the 1.5 to 1 floor area ratio of the manufacturing zones and the CM zone. Staff recommended denial of the case, which was unanimously adopted by the City Planning Commission. The plan is very specific, and the reason that the plan denied this case, recommended denial of it, is the plan is very specific as to these properties and any changes to them in the Harbor City community. The plan text and policies mention these properties specifically twice, basically stating in the portions of the Harbor City Wilmington area the land uses with corresponding MR restricted zoning classifications, which are intended to stabilize industrial land reserve while assuring that industrial development be compatible with adjacent land uses. And also the policy 3.21 of the plan, that to protect areas designated for industrial uses and proposed for the MR restricted zoning classifications on the plan map from unrelated commercial and non-industrial uses, and upgrade such areas with high-quality industrial development that is compatible with the adjacent land uses. The Planning Commission adopted findings. Basically, the required city charter findings could not be made on this particular case because of the language of the community plan that these areas should be maintained for their industrial uses and that should not be protected from unrelated commercial uses. The elimination of the MR icon would permit the enactment of the M1 or CM zone uses, which would permit the establishment of a full range of commercial uses in the area, and also CM zones, which allow the R3 density residential development. Such a change was inconsistent with the charter finding, and was also inconsistent with good zoning practices in that though the CM zone is within the range of zones for the limited industrial, even with the removing of the MR designation, this would become an inconsistent zone because our industrial plan designations do not permit residential uses in them. We also recommend the denial of the case for demographic reasons. Looking at the demographics for the Harbor City community area, these 2010 population forecast of the current community plan calls for a population of 92,000 and a number of 26,900 residential units. The current 2008 population numbers, which were the most recent estimates for the population, show 81,000 people living in the area with 22,600 units. Basically, the plan area is built out for 88% of its population estimates, and 84% of the housing units have been developed in the area. And we did not think that this is a reason for changing industrial land into residential uses, as there were already residential capacity within the plan for more residential properties. The Commission denied the redevelopment agency also showed up, and you have a letter from the redevelopment agency before you in opposition to the case, as they are encouraging the preservation of industrial land throughout the Wilmington Harbor City area. And the relevant numbers from that is that there are 2.7% vacancy rate within industrial properties within the South Bay area, which would include the Wilmington Harbor City community area. 18% of the jobs are within the industrial sector, and 25% of the property of the businesses within 1 mile area are in the industrial categories. Commission denied the zone change in the plan amendment. The mayor concurred in the recommendation recommending denial of the plan amendment to the city council.
I look at this map and I just need a little bit more insight. We look at 260th Street and you look at the frontage you have on Seattle Avenue. You have a residential frontage with a machine shop putting industrial right behind it. Is that what exists today?
That is what exists today, yes.
When you look across the street, is that residential?
Yes, there are a number of R3 zoned 2 to 3 story multiple family developments on the south side of Bellport Avenue, with the exception of the warehouse that you see at the elbow of Bellport and 260th Street.
So where we see on this map residential, that really is residential?
Yes, it is.
Okay. Now, the subject site for today's case, where it says Club Lodge Hall, is it just that section of the block, or is it the whole block?
Yes, it's 5 lots going in a westerly direction from Bellport Avenue, so it would be the 5 lots that you see through the parking lot that you see designated there.
So that would, what can I say this?
Which is how they could get all that number of units within a 1.5 to 1 FAR.
So it's not the whole frontage, it's just half of it, seems like.
Correct.
Because it says machine shop printing, that stays?
That is under separate ownership.
Okay, so what they are asking for is essentially what we did on the other block where it says residential with the frontage on it.
Correct, except this one goes back to the alley that you see there. To the north of the property line, and as you see on the part with the residential portion to the west of there, it's basically the properties are split between industrial just to the south of the alley and residential to the north of 260th Street.
Okay. Okay. Thank you, sir. Any questions for Mr. Roche? No? Okay. Madam Council Member of the Mighty District 15.
Thank you, Mr. Chair and Councilmember Krikorian. Thank you for hearing this today. Boy, when I was sitting here listening to it, I'm going up against everybody. I'm going up against the mayor, the planning staff, his planning commission, everybody to ask you to overturn
And the
this.
CRA, too.
And the CRA. I forgot the CRA. I'm going against everybody. And, you know, I love the planning staff. I love the planning commission, particularly when they vote in favor of what I want. But this one, I'll tell you, I'm here, and I don't. How many times have I come before you in your committee? Not that many times.
Let me count them.
I'm here because this project, I think, makes sense in this particular area. And I actually do think right now it would be perfectly reasonable and perfectly within our scope as the city council to change the zoning in this particular location. This project will actually, I think, beautify an underutilized industrial lot. Nothing against UFCW's Union Hall. Lovely place, but really, to me, a 30-unit housing project really will improve this neighborhood. By the way, it is, as you saw, it's located on the outer edge of a small industrial area which has 80% vacancy rate. And more importantly, it's right directly adjacent to a neighborhood, a residential neighborhood. I was just there Friday morning. That's where we had our big Martin Luther King labor breakfast. I drove from my house through residential neighborhoods to get there. It's really very compatible with the residential area. It makes sense to me to change the zoning to commercial manufacturing, which will allow residential, but also will preserve the possibility of light manufacturing in the future. It will create jobs. I mean, I know CRA, everyone's looking at the loss of jobs when you change industrial land, but actually, I think that's just something that we're kind of hoping for someday, and this project will actually create 300 good jobs. I think that's what we need to look at.
Councilman, I have one question for you.
Yes, you want me to finish my speech?
I thought you were done. I'm sorry.
Almost.
Didn't mean to cut you off. Please continue. We want to hear this eloquent prayers of wisdom.
I think this is a project that you would like. It's LEED certified. It will recycle many materials and include energy and water-saving features. And it has my support. It also has the support of the surrounding community and the neighborhood council. And again, I think this is sort of how, community plans are great. General plans are great, but we know that the process for talking about these kinds of things happen during those updates, and we know, based on our budget crunch, many of these plans are not going to be updated for a long time, and so I've always envisioned neighborhood councils, city council members having these discussions really sometimes outside of these updates. This is a perfect example. So I think you would make a great decision to overturn the planning department's recommendation. No offense to them. It's nothing personal. I understand the rationale, but I think we can make a good case for this, and the neighborhood would, I think, improve as a result of this. Okay.
You mentioned a vacancy rate of 80% in surrounding industrial uses. Has there been any study or any analysis on why it has remained vacant? Do we know?
We have any studies on this? Yeah, I think it's probably, manufacturing jobs have left. I think it's the economy. I just think...
Is that like a contamination issues or cost for brownfields?
I don't think so.
Anything like that?
No.
Okay.
I think it's the economy.
Okay. And how long have they been vacant, do you know?
The vacancy rate?
Yeah. How long has it been like that?
How long has the vacancy rate been? A good couple of years, says Darlene Kuba.
Okay. Councilman, any questions? No? Okay, thank you. Thank you for your time.
Thank you very much.
Your glorious presence in this chamber. Thank you very much.
I may sit here and keep my eyes on you while you make your decision.
Keep your eyes on them, huh? All right, folks. Thank you, Ms. Han. Our next speaker is Darlene Kuba, then George Hernandez, then followed by Chet Kohler.
Good afternoon.
Good afternoon.
Mr. Chair, Councilman Kokorian. My name is Darlene Kuba, and I represent Ricky Kaza and Rod Diamond of the United Food and Commercial Workers. And today, we are appealing the entire determination of the City Planning Commission. On the handouts I provided you right before you here, on page 2, just like to say that we have requested a general plan amendment to the Wilmington Harbor City Community Plan to remove the MR1 designation for the project site from the planning's land use map, which pursuant to footnote number 12 states no housing allowed in the MR1 zone of the community plan, identifies and limits specific limited manufacturing areas in the community plan to MR1 and MR2 land uses only. And concurrently, we are requesting a zone change from MR1 to CM zone to permit the construction of 30 residential townhome style dwelling units. On page 3 of the surrounding properties of the handout, you'll find many multifamily residential in around the subject site, which is directly across the street as well. There are many, many multi-residential 2-story, 3-story, and 4-story complexes in around. Page 4 is multifamily residential, and you could see where the residences are all 2, 3-story, and 4 stories all along. Now, the corner right-hand photograph of the industrial and residential, you'll see a residential on the right, which is a multifamily residential complex, and the industrial site to the left of it. On page 5, the subject site is in a small industrial pocket of a manufacturing zone, and according to Janice Hahn, 80% is vacant. And on photograph number 7, down below on the right, you will see that same residential multifamily. It's a condominium project, ownership, condominium project. And so if I can go on for
Can I just
more minutes.
conclude,
Yeah.
Ms. Kuba?
So the general plan and specific plan in this area has not been updated for many years, and it won't be updated in the distant future. The retention of the manufacturing property has been aimed primarily at the downtown and West Los Angeles areas, and to apply this industrial land use policy is inappropriate. A policy of this importance should be analyzed and studied carefully before it is applied throughout the entire city. This includes obtaining important input through public hearings, and doing so will provide transparency and avoid problems and unintended consequences. And I'd like to say the subject site is not in the CRA area, and there will be no job losses in the area. There is, and also support of this project is the Harbor City Neighborhood Council, the Carpenters Union, and the Building Trades.
Thank you, Ms. Cooper. George Hernandez?
Good afternoon. My name is George Hernandez, and I'm a regional manager with the LA County Economic Development Corporation. And I work on the ground every day to attract businesses to the area, to the county, and to the city of Los Angeles. And I want to thank this committee for allowing me to present at this hearing on the importance of preserving our dwindling industrial land base. First and foremost, our city desperately needs jobs. For the last 3 decades, the city of Los Angeles has markedly underperformed in terms of creating jobs for its 4 million residents. A quarter century ago, the city had about 61 jobs for every 100 residents, but now has less than 45 jobs for every 100 residents. And while the city added approximately 1 million new residents from 1980 to 2009, not a single new net job was created for those residents during that 30-year time period. In fact, the city of LA actually lost more than 150,000 net new jobs. There are many reasons for this stunted growth, but one of the chief causes is the extremely high rate of conversion of our diminishing industrial land base to uses that accommodate population growth but not job growth. While we all agree that an adequate supply of housing, especially affordable and workforce, is a critical need, housing can be located all over our city. According to the City of Los Angeles Housing Element, the city has enough land zoned properly for residential or commercial uses to accommodate more than 382,000 residential units, or nearly 3 times the number of units needed to satisfy the city's regional housing needs assessment of less than 113,000 units. Thus, there is no need to use industrial land to solve the city's housing problem, especially when one considers that once we lose industrial land, we never get it back. Here in Los Angeles, industrial land supports the largest manufacturing sector in the United States, employing almost 155,000 workers. What's more, industrial zone land supports more than just durable and non-durable manufacturing jobs. Today in Los Angeles, industrial means skilled, high-value, and high-wage jobs in growth areas vital to our city's economic prosperity, including biomed, high-tech, and green technology jobs.
Thank you, Mr. Hernandez. One question. When we look at the vacancy rate in the industrial pocket now, it's been like that for several years. What are we waiting for? I mean, you have another alternative use?
Yeah.
I mean, it's been empty, 80% of it.
Right. And you can't answer that specifically.
But you know what I'm saying is that's the tension that we're going through.
I understand. I think the other argument that I want to put forth is that, again, we only have a certain amount of industrially zoned land. So again, it's hard to get it back, and there are so many companies that come to us saying, hey, we want to be near the port. So now that we're going to a green economy, I think there's going to be opportunities to use this type of land.
Gotcha. Thank you. Okay, Mr. Kohler? Chet Kohler? Is Chet Kohler here? One last time? Last call, okay. Mr. Spivak? Welcome, Mr. Spivak.
Thank you. Don Spivak from the Community Redevelopment Agency, Mr. Reyes, members of the council. Thank you for the opportunity to just expand a little bit on the fact that CRA was mentioned. The Community Redevelopment Agency and the Planning Department over the last several years have conducted an extensive analysis of industrial land throughout the city, and have identified that, as was just mentioned, we have been experiencing a loss of jobs, a loss of industrial land, while we have been adding population, and that has been exacerbating a very serious problem of a jobs housing balance. There are a couple of things to just expand on and answer some of the questions that were raised. First off, our industrial vacancy is around the city quite low. For the most part, most of our industrial land is in areas where the vacancy rate is around 1%. In a few areas, it may be as high as 2.5% to 3%, but generally there are very few industrial vacancies. Where there are industrial vacancies, it generally reflects a lack of certainty on the part of the surrounding owners that the land around them will continue to be industrial, and the uncertainty that they will be able to continue in business because of what they see as the intrusion of non-industrial uses into what had been solid industrial areas. This particular site is about a quarter of a block, that the balance of which is industrial. It is surrounded on three sides by additional industrial land. And intruding in this area, as has been shown in lots of other areas of the city, particularly with residential uses, tends to cause those other uses to move out for a variety of reasons. They include the pressure of residents being concerned about truck movements, noise, and hours of operation. They include the fact that in many cases land values begin to change dramatically because residential land can bid up the price of land, and industrial uses either can make more money by simply moving away and allowing the land to convert, or cannot afford to remain there and expand. So these have been factors that have caused a lot of the industrial decline. Los Angeles right now only has 8% of its land zoned industrial, and because of the intrusion of non-industrial uses in the recent years, a quarter of that land is already used non-industrially. By comparison, in some other major cities, New York is at 10%, and they're complaining they don't have enough industrial. Seattle, 12% of the land is industrial. San Francisco, 14%. Minneapolis 11%, Baltimore 16%, and most of these areas are looking to increase their industrial properties rather than to decrease them. We are a largely built-out city. The ability to find other places to replace the lands that become non-industrial is very, very difficult, if at all possible. And so, as a matter of policy, we urge the retention of industrial land wherever it is possible to do so. Thank you.
Just when I look at a case like this, because I know it's been a lot of studies and experiences throughout the city, but I can't help but see the dominant nature of this neighborhood seems to be residential already. If you have an 80% vacancy rate, is it behaving like a residential even though it is zone industrial?
Not necessarily. The industrial areas that were designated here have been there of long standing. Whether there are vacancies right now at that number, I'm depending on what other people have said those numbers are. I haven't myself verified them, but they may be indicative of something that is very much a question of the local economy at this very point because of the economic situation. The fact of the matter is that there is growth taking place in industrial activity demand because of the port, which is fairly close by. And as was mentioned earlier, once we lose industrial land, it's essentially gone forever.
And this is what I struggle with, because this is parallels my experience in my district. In this pocket in San Pedro, like in pockets in Northeast LA and South Central, they evolved without the planning discipline in place. You had residential right up against M3, M1 zones, so there was a built-in clash because of the history about where these neighborhoods evolved without the planning discipline. Fast forward 80, 90, 100 years, all the rail spurs are outdated, they don't exist. You have a dilapidated industrial infrastructure where brownfield conditions to clean these properties cost a lot of money. And given the size of these parcels, maybe at one time they made sense, but today manufacturing plants, manufacturing centers require much greater parcels of land. And so you have this conflict, and you got this transition occurring in places that, yes, we are losing industrial, but to invite someone to come in has been very, very hard, particularly in my district. So this, to me, echoes that dilemma, where you see a trend occurring where you have live workspace, residential, what's happening just east of downtown, and you've got this tension because people need to live somewhere. And so we've got this vision, and I'm listening to the councilman's vision of she sees her industrial moving in another area in her district much more consolidated. It has its buffer zones. It can be mitigated. You can take the trucks away. You can minimize the conflict between the transportation vehicles, and you can increase quality of life here in a way that is, it's going against, at one level, and this is my intention, as a planner, I'm thinking spot zoning big time. Okay? I'm seeing it. But on the other hand, I'm listening to the council member's vision, what she wants to do, and I see the preponderance of residential already. So where do we give? Or do we stick true to that principle? And that's my struggle right now. But thank you for your presentation. And I have the utmost respect for your work. Let's just spit back. Thank you.
Thank you.
Mr. Krikorian, please come on.
Thank you, and I appreciate and I understand your tension, but I love my CRA and my LAEDC, but we have had an industrial park in Wilmington. That's been a CRA project for 35 years that they are unable to fill with good manufacturing jobs right adjacent to the Port of Los Angeles and Long Beach. So I love hearing them say that, but I have been begging them to put their heads together and focus on that industrial park in Wilmington that is perfectly situated, like you just described, for good jobs that have a nexus to the international trade industry, and they've been unable to do it. So thank you. I just had to say that on the record. I'd welcome them. Lancet's a project that we're building in South Los Angeles, 9 acres of, we hope to bring in warehousing and manufacturing jobs. Again, have yet to attract the first tenant there as well. So I got places in my district. I'm more than happy to work with CRA and with any economic development organization around to bring good jobs to Los Angeles. This doesn't seem to be appropriate to hang on to something that just isn't happening there.
But to me, Brian, do you see this evolving into a residential zone, Councilman Burhan? Councilman Burhan, in terms of, pardon my bluntness, but do you see this evolving into a residential zone? You see preserving the industrial pocket here. Like, what's the direction given your vision?
Yeah, I see it moving more towards residential. I still think I represent interesting areas that are the line is becoming blurred between industrial and residential. Unfortunately, that's the way they have. The history has been both in Wilmington and in Harbor City, mainly because of heavy industrial associated with goods movement industry. But it's a very blurred line between industrial. I can see, though, preserving some industrial pockets there, but it doesn't look like the future of industry in this particular area is very promising. And I think the comment that possibly because owners of industrial land are feeling like they're going to be more constrained by residential needs and concerns, but it's already behaving like that. That's because I think of the residential that's already there. So I think you're sort of really just going along with how it's behaving anyway.
Thank you. Thank you. Councilman Krikorian, any questions or observations?
Well, I certainly respect the concern about losing industrially zoned property and how we need to make sure that we have adequate industrial land that we can use to continue to expand and create jobs. But as you look at this map and see the encroachment, if you will, or the surrounding residential zones, it seems to me that this is we can't always say that one size fits all, and the economy of that region seems to be more towards the larger expanses of property, as the council member described, rather than these small pockets. And at the same time, in order to be able to fill the jobs that we're trying to create, we need to have adequate housing as well. And so it seems to me that we want to encourage more housing in places like this that can accept more density and more units put in that will be close to those jobs that the council member and others are trying to create in that part of Los Angeles. It's better to have housing closer to where those jobs are going to be. It's better for the environment. So I think, especially as you look at the pictures of the surrounding area here, this really does look like a property that would be appropriate for residential use, and what I've heard, I'm supportive of this.
Okay. Is there anything else anybody else wants to add? No? Okay. Well, I struggle with this, but I respect the work of the planning department and the CRO and what you're doing, but I do give it, in this case, a high priority to the councilman who has a sense of direction. She's represented this area for a while now, and I've seen the trends that are occurring, and I would support the appeal filed by Ricky Casa, United Food and Commercial Workers Union, and that would be my recommendation. Is there a second for that?
Second.
Subject action of this committee.
Councilman Jerry Burge, City Attorney's Office, you should also direct staff to present findings at council, because this, of course, was a denial, and now you're recommending a grant.
Okay.
Yeah, we still have to write an ordinance on this.
Okay, thank you. Thank you very much. All right. What's next, Roberto, other than public comment?
Actually, you have item 14, which is the planning department's report, no report. Then we have the two closed session items.
Okay, we can take public comment now before closed session. Would that be okay, Madam Attorney? But we do have one card on number 14. That's Noelle Weiss. Mr. Weiss, number 14, although she's not here, you did submit a card. I'd like to hear from you, if you'd like.
You know, my only comment, Mr. Reyes and Councilmember Krikorian, on this SB 1818 project, I mean, the law that you did pass requires the planning department to send to the neighborhood councils these applications, and I'm not sure the planning department is doing it. They didn't do it in in this SB 1818 that just came down in Mr. Garcetti's district, and it could be that because what's happening, I think, I'm starting to get a sense, because again, we're back to the data request again. My sense is the planning department maybe is going to all these developers and saying, oh, you already got approval for 50. We'll just double it to 100, and we'll use the same documentation and everything else, and we'll just call it SB 1818. Meanwhile, of course, the community doesn't know about what's going on. And honestly, council member, I think that if we can get a decent dialogue here between the neighborhood councils and these developers, I think we can get a lot of these projects going. But the problem is some people are going to wake up someday and they're not going to be getting this documentation. And I want the planning department to follow what the rules and requirements are, which is to give the neighborhood councils copies of all of these density bonus cases, and they're not doing it. So that's my only comment, and I appreciate your consideration.
Thank you, sir. Okay, we'll go to closed session.